for the first respondent with A.A. Samoa Samoa.
If your lordships please, Pierre Kotuampa appears for the second respondent. My lords, with me are my learned colleagues, Frank Davis, Kweku Eserfi, and Ya Opong.
So let me have the file there. We have filed a motion to stay proceedings, and we also have a motion for leave to file an additional ground of review to replace a paragraph of our original statement of case and file a supplement to the statement of case. My lords, in respect in respect of the motion for stay of proceedings, your lordships may appreciate that we indicated that that was for stay pending the hearing and determination of the review application. If your lordships are going to proceed to hear the review application, then clearly that motion for stay will be...
It's moot.
I'm sorry.
It's moot.
Indeed.
Okay.
Indeed.
So, yeah, so should I proceed to formally strike it out as withdrawn?
Yes, well, I just wanted to be clear that you're proceeding to hear the
Thank you.
application for leave, in which case we are withdrawing the motion for stay.
Okay.
So we respectfully ask to withdraw the motion for stay and to proceed to take the other application.
Council, I think two applications are moot. So to level the playing field, maybe withdraw. The abridgment of time to is moot. So if the two, and you filed it, yes, that one too is moot.
Yes, so your lordship, I wish to withdraw that application.
My court, the motion for stay of proceedings is struck out as withdrawn. Yes.
But my lords, with respect, I wish to withdraw the motion for abridgment of time.
Yeah, okay. I have to have that application, which is still pending, to also be formally struck out as withdrawn. Yes. Ground filed by the first respondent hearing is struck out as withdrawn. Yes.
I'm not grateful to the court.
Counsel, with due respect,
My Lord, we have a motion. We have a motion for leave to file an additional ground and to replace paragraph 28 of the original statement of case and file a supplement to the statement. Very well. Very well. Very well. All right.
Please, you may resume your seat, please.
Radio.
We are still bringing you the live coverage of the proceedings of the Supreme Court. The court has just risen right now for certain processes to be filed. We will be reaching out very soon to our court correspondent, Wilberforce Asare, to give us an update on exactly what it is that is happening in court and what elicited that rise and what the processes are going to be subsequent to that. But yeah, we are still here in the studios. It's our extended version of the Asase Breakfast Show. Just talking to my panelist in here, we know that the petitioner has now obliged the court, yes, and has filed their witness statement. But we are informed that Mr. Wilberforce Asare is on the line. Wilberforce, if you can hear me, what just happened in court and what are the next processes that are going to be happening?
Okay, Benjamin. So a few things have happened in the Supreme Court a moment ago. The first thing that has happened is that when the court constituted, the lawyer for the petitioner, that's Chachuchi Kata, attempted to move his motion for stay of proceedings. However, the court told him that it has decided that it will hear the review application. And so to the extent that it has decided to hear the review application will mean that the application that was asking the court to halt all proceedings is moot. That is, in essence, is no longer relevant. And so lawyer Chachuchi Kata then withdrew the application and the court struck it out as withdrawn. Now, if you remember, when the Electoral Commission's lawyer filed an application for abridgment of time, it was for the purpose of hearing the case, the review application. So now that the review application is going to be heard today, the 28th, the request to abridge the time for hearing is also moot. And so the EC's lawyer also withdrew that application, and the Supreme Court struck it out also as withdrawn. Now, the next thing that happened is that Mr. Chachuchi Kata attempted to move his application for review, and the presiding judge, the Chief Justice Enini Yeboah, says that he thinks that the enhanced bench should be the one hearing the review application and not the current bench. And so they decided to write back to the chamber so that they will reconstitute by way of the enhanced bench. And so it's expected that when the court resumes, there should be 9 judges sitting down to hear the review application before the case can continue. You know that we are expecting the court to give further direction as far as the substantive petition is concerned. But for now, the court will reconstitute with a panel of 9 judges to hear the review application. Once that is done, the substantive bench, which is the 7-member panel that just sat, will come back and will continue with the petition itself. And so for now, the court is on recess. When it resumes, it's going to be an enhanced bench that will take care of the review application that lawyer Chachuchi Kata has filed on behalf of the petitioner. Maybe we should just briefly talk about what this review application is. The review application essentially is about the fact that sometime in this case, I think on the 20th of January, the applicant's petitioner filed an application seeking permission to serve some interrogatories on the Electoral Commission, essentially to ask the EC some 12 questions that the petitioner believes can help them in the preparation of their witness statements and other things. Now, the ordinary bench, the 7-member bench, struck out that application and said that the questions that they were seeking to serve on the EC is irrelevant, and so they should proceed with the case. Now, the petitioner's lawyer were not satisfied with that ruling, and so they are asking the Supreme Court to review its decision, as it were, to reconsider the decision to dismiss their application to serve interrogatories. So that's what the review bench is going to do when it sits, which is the 9-member panel. Benjamin.
Okay, Wilberforce, we see that the 9-member bench has sat, so the Supreme Court is reconstituted. So we would want to cross over into the court, Supreme Court, the chamber, and take the proceedings as they go ahead. We'll come back to you in good time. Yeah.
Okay.
May it please your Lordship, I appeal with me, my learned friend Tony Lita, for the petitioner applicant.
May it please my Lords, Justin Amenuvo appears for the first respondent with AA Somwa Asamoah.
If it pleases your Lordships, Akoto Ampah for the second respondent. My Lords, with me are my colleagues Frank Davis, Kweku Srifi, and Yao Pong.
Radio.
My Lords, we have before you an application for review that is brought under Rule 54 of CI 16, and in connection with that application, we have also filed an application on notice for leave to file an additional ground of review, replace paragraph 28 of the original ground of the statement of case, and file a supplement to the statement of case. Lord, this application is brought under the inherent jurisdiction of this court. In hearing the application that we have for review. And my Lord, I would respectfully refer also to a number of precedents of this court, particularly in respect of the matter of leave to file a supplement to the statement of case. And I firstly refer respectfully to the case Ellis Tamaklo against the Republic. Ellis Tamaklo is an unreported decision, as far as I'm aware, of the 20th January 2011. And your Lordships will forgive me if it is reported and I'm not aware of the report, but I have a copy of the
suit number, please.
The suit number is CM number J7A/1/2010. And in the ruling of the court read by Justice Atuguba at page 2, after referring to the applicant's grounds, His Lordship says, in his supplementary statement of case, he identifies the issues raised for review as follows. And I refer to the passage in his supplementary statement of case. He identifies. So, my Lord, the court clearly granted leave, and a supplementary statement of case was filed and relied upon and considered by the court in that case. That was a review application in the Supreme Court of Ghana. My Lords, I also wish to refer your Lordships to the case of Standard Bank Offshore Trust Company Limited, substituted by Dominion Corporate Trustees Limited, against the National Investment Bank Limited and others. That was an appeal to the Supreme Court from the Court of Appeal, and in that case, the appellant, that is the first defendant appellant, applied for leave to file a supplement to the statement of case. That is also a civil appeal number J4/2016, civil appeal number J4/63/2016. That judgment of the court read by Justice Benin, there is explicit reference made at page 2 to an application to file a supplementary statement of case, which was granted on the 6th April 2017. And the court proceeded in its judgment to consider the matters raised in the supplementary statement of case filed pursuant to an order of the court on the 6th of January. I also wish respectfully to refer your lordships to a decision of this court Hassan Amidu versus Mutiu Alawiye and 6 others, which is a decision in a civil appeal J4/54/2018. And in a decision of this court on the 24th of July 2019, reference is again made to the fact that a supplementary statement of case was filed, and that reference is actually made in the dissenting opinion of Justice Appal in that case, where under the heading Plaintiff Submission in Brief, he refers to the supplementary statement of case filed on the 27th of June. Yes, my lord.
The last 2 cases you cited.
I'm sorry.
The last 2 cases you cited relates to an appeal, as you said. The last 2 cases you cited relates to an appeal. I think that's what
Yes, the last 2 cases, yes.
I'm not appeal, not a review.
My lord, there is, with the greatest respect, in this context, there is no difference, because in respect of an appeal, the same requirements, my lord, in this connection, the same requirements as regards how an appeal is to be lodged are provided. And I respectfully wish to refer your lordship to the rules governing appeal. That is Rule 15, Sub-Rule 6, which says, in precisely the same way as is provided for in review, it says the statement of case of each party to the appeal shall set out the full case and arguments to be advanced by the party, including all relevant authorities and references to the decided cases and the statute law under which the party intends to rely. And B, in the case of a respondent, may include a contention that the decision of the court below be varied. My lords, that yes, 1511 says, notwithstanding anything to the contrary contained in these rules, any party to a civil appeal may at any time before judgment apply to the court to amend any part of the statement of his case, and the court may, having regard to the interests of justice and to a proper determination of the issue between the parties, allow the amendment on such terms as it may consider fit. Now, my lord,
when you go to review, is there a similar position
My Lord, there is no similar provision, and we are not asking, as far as the supplement is concerned, that is not an amendment. As far as paragraph 28 is concerned, yes, we are seeking to make an amendment effectively, but in respect of the supplement to the statement of case, that is distinct from an amendment, because respectfully, a supplement is meant to add some things to the statement of case. An amendment, respectfully, is meant to change something that you do or something that you've already provided the court. So there is an important distinction. And what I'm drawing respectfully, what I'm drawing attention to in the first instance is in respect of the supplement to the statement of case. I will come to the amendment also, if your lordships will allow me. So I'm respectfully saying that not the review jurisdiction in its statement about what should be in the statement of case is no different from what is provided for in respect of appeals. And the review jurisdiction is provided for in this particular instance as far as the statement of the applicant's case is concerned. The review jurisdiction is provided for in Rule 56.1. The application for review shall be by motion supported by an affidavit and accompanied by a statement of the applicant's case, clearly setting out and fully arguing all relevant grounds on which the application relies. And my respectful submission is that that is no different from Rule 15.6a, referring to appeals, which says the statement of case of each party to the appeal shall set out the full case and arguments to be advanced by the party, including all relevant authorities and references to the decided cases.
Mr. Chikata.
Yes.
This way, I'm here. This way. Is there any reason why that 1511 is not repeated for this one?
My Lord, I cannot say that there was a reason in the minds of the Rules of Court Committee, but as I indicated a few moments ago, I wanted to finish my submissions on the supplement to the statement of case and then address you on the amendment, if respectfully, if that is a satisfactory approach. I wanted, because my Lord, my lady's question is getting back to the amendment issue, and I respectfully requested that I be allowed to complete my submission on the supplement to the statement of case, because I have a couple more authorities that I wanted to advance. So I will wait. I will wait. Very well. So in respect of the supplement to the statement of case, I have just referred your lordships to Amidu and Alawiye, and I proceed further to...
Chikata,
Yes.
I want to understand your argument. Your submission is that it has been the practice to allow supplements, and therefore this court should allow the supplement as a matter of practice. And you also refer, that's it, right? As a matter of practice. Not because the rules are, not because you can see an indication in the rules, but because going through the decided cases, you see that it has been the practice. Is that your submission?
That is not my submission.
What is your submission?
My submission is that your lordships, in their wisdom, in interpreting and applying the rules in CI 16 have considered it an appropriate exercise of jurisdiction to grant leave for the filing of a statement of case. Your lordships have done that. And therefore there are precedents that show your lordships interpreting and applying the rules concerning review as well as the rules concerning appeal in a manner that allows for a supplement to be available to the court as part of the process of determining an appeal in one case and a review in the other case. That is my submission. And my lords, respectfully, I do not believe that the practice of the courts in terms of the precedent that I cited, I don't believe that that practice has simply been an arbitrary practice, especially when, as I show, there is a certain pattern and there is a certain consistency with which this court has enabled counsel to file a supplement where it considers it appropriate. And my lords, the next case that I want to cite, in fact, illustrates exactly this point as regards the court's considerations when an application is filed for leave to file a supplement of case. This is the case of Nora Otu and Reuben Otu, which is a civil appeal number J7/3/2015, and in that instance, a single justice refused an application to file a supplement to the statement of case. And then, when it went before the full panel, they upheld the decision of the single justice. And the reason they upheld that decision was not because the rules did not allow for a statement of case, but because the lordships held, per Justice Badegbe, that this particular application was seeking to bring a new matter that was completely unrelated to the issues in the appeal. So in that case of Nora Otu and Otu, the determination by the court was that in order to try to bring in new matter, the court would not exercise its jurisdiction to allow for leave. The court did not say that the rules do not allow leave. The court said, in respect of the new matter, we cannot grant leave. And my lord, the final case in respect of a supplement, the final case that I wish to refer to is again your lordships. I'm sorry, there's actually one more case before I get to the final case. That is Nunu against Ataglo. Nunu against Ataglo.
Could you kindly spell Ataglo?
I'm sorry.
Can you spell Ataglo?
Ataglo, A-T-A-G-L-O.
Thank you.
And that is civil appeal number J4/73/2018. That is a decision that your lordships rendered on the 28th of July 2020. And in that decision, Her Ladyship, Justice Doji, in reading the judgment of the court, as I think it was, a unanimous judgment, Her Ladyship again refers to a supplementary statement of case filed by the defendant upon the orders of the court that the parties address us on the legal effect of a provisional land certificate. So in that case, significantly, the court itself ordered a supplementary statement to be filed in order to address a particular legal matter. And that was exactly what happened also in the last case that I would like to cite, which is a case, consolidated rates, decided on 25th of June 2020, National Democratic Congress against Attorney General and the Electoral Commission of Ghana and Mark Techi Banson. That suit, well, the first suit is numbered J1/9/2020. And the second suit, which was consolidated with it, is J1/12/2020. So National Democratic Congress versus Attorney General and the Electoral Commission of Ghana and Mark Techi Banson against the Electoral Commission of Ghana and Attorney General. Now, my Lord, in that case also, in the decision that was read by Justice Professor Kuti, reference is made to the fact that the court directed the second defendant to file a supplementary statement of case to provide the legal basis for the non-inclusion of the current voter identification card as a document to be used for the identification of a person who applies to be registered as a voter in the compilation of a new registered voter. Option was given to the other parties to file supplementary statements of case if they so desired. All the parties duly filed supplementary statements of case. So, my Lord, what I'm respectfully submitting is that your lordships have recognized that the supplementary statement of case, or the supplement to the statement of case, as we have referred to it, where it can assist the court to address the matters that are an issue before it, may be entertained. Where the supplementary statement of case can assist the court in addressing the matters before it, it may be entertained. Now, my Lord, I would like to refer also to a decision which I do not yet have a certified true copy of, but a decision made on Tuesday by your lordships in the case Republic versus the High Court, who ex parte Attorney General.
Asasi Radio. Asasi Radio. 99.5.
You're still here on Asase Radio 99.5. We are bringing you the live coverage of the 2020 election petition hearing in court. We seem to have lost the sound from the court. As soon as we get that, we will be going back to the Supreme Court to bring you the sound. But if you're watching on Facebook, we are live on Facebook on Asase Radio 99.5. We're bringing you the live video as well as the sound coming from the Supreme Court of Ghana here in Accra. But just before we lost the sound,
I
think the sound is back. We'll go for that.
We are here to argue the Hohoe case, and I do not see.
Citing that case in course of argument, yes, he is entitled to refer to a decided case. Even at the Supreme Court, we can refer to a Court of Appeal decision. Yes.
Very well.
Yes. It's just...
But I want to correct a wrong impression. The application was not merely to file a supplementary statement of case. The application was to file an additional ground of appeal. And it was ground of review, additional ground of review. And it was on the basis of the additional ground of review that the supplementary statement, you wanted to file a supplementary statement. So if you cannot file additional ground of review, then there is no need to file a supplementary statement of case. If the supplementary statement of case is based on the original grounds of review, it's a separate matter. There should be a distinction between just asking to file a supplementary statement of case in respect of the grounds of review that we have already filed, and then leave to file additional ground of review, and then a supplementary statement of case because of that additional ground. There are two different things.
My lords, with the greatest respect, that application, which also happened to be filed by us, that application was indeed to add grounds of review and to file a supplement, and that supplement was to address not only the additional ground of review, but that supplement was even to address a ruling of the court in respect of bias, which we had applied for and we were still waiting to receive. That supplement was to address even that. And we were not allowed on the simple basis that the rules regarding review did not provide or did not allow for such.
Mr. Chikata, if I recall, that supplement was also to allow you to fill in holes that you had left in your submissions. So if we can get back to today's business, please.
We did not, it was not meant to fill in holes, and that may be your lordship's interpretation.
The holes were numbered Q, N, and 0. I was and O. I was actually part of that panel. Thank you.
The whole, your ladyship, the grounds were numbered Q, R, S, T. I'm not sure I know what the Q, N, and O that you're referring to. The grounds were numbered Q, R, S, T were the additional grounds that we sought. My lords, I mean, the documents are there, so there's perhaps no need to try to dispute, but I don't know what the O that you're referring to is.
Omissions, you said, if you remember, you said you had applied for the order of the court and you have not received the order. And so you left some holes, some missing holes.
No, my lords,
you had applied for an order from this court and you have not received the order.
My lords, with the greatest respect, what we said was that in the draft statement of case, which we attached to our affidavit, where we had Q and R, yes, there was nothing written under Q and R. It was blank. It was blank, and we gave a reason. The reason being that we have not received the ruling to enable us to address those grounds. Well, I mean, the rather colorful language of filling holes may not apply to what we were seeking to do, because
Mr. Chikat, I think we should have timed you.
I'm sorry.
I think we should have timed you from the beginning. We should have given you time from the beginning. Because it looks as if you are going...
My Lord, I'm not... My Lord, respectfully, my submission is that that decision that was delivered by this court on Tuesday, by another panel of this court on Tuesday, that decision was in clear error. And it was in error because it was not consistent with a pattern of decisions which I have referred to, in which this court has exercised its discretion to grant leave for the filing of a statement of case. And my Lord, my fundamental submission is that this court, in the exercise of its discretion in hearing a review, is able to consider an application for a supplement to the statement of case. And my lords, I am respectfully submitting that the critical consideration for this court is really as to whether that supplement to the statement of case will enable this court to administer justice. And in a matter such as in that case, where the court was being urged to allow for the statement of case, not only because even a ruling in respect of which the original statement of case had been made, that ruling had not been made available to the party, but also because, as the court, as was indicated, there were a number of unreported decisions which the court was now being furnished with. So, my lord, where the application to file a supplement is to enable the court to be furnished with additional decisions of itself, which decisions are binding according to the constitutional provisions governing the exercise of jurisdiction. My respectful submission is that this court is able to exercise the jurisdiction for that supplement to be made available. Now, my lord, in this case, as your lordships will see from the drafts that we have submitted, the draft of the review, the draft of the supplement, we actually seek to provide this court with further assistance by way of additional authorities that are made available. Now, my lord, if I may, just before concluding, if I may touch on this question of amendment and how it differs from the supplement from the statement of case, which has been raised by your lordships. Now, my lords, in respect of appeal, yes, there is a specific right provided for applying for an amendment. There is a specific right. And my lords, my respectful submission is that the distinction between that and the review situation is fairly simple. The distinction is as follows. In the case of the appeal, the appellant is given a distinct right to ask to amend. So that is a specific thing provided for in the rule. In the case of a review application, my respectful and humble submission is that it is open to the court in the exercise of its discretion in hearing the review, where it finds it appropriate in the interest of justice to allow for the supplement to the case. So that is the distinction that I wish, in answer to your ladyship's question earlier, that is the distinction that I wish to make clear. That in the case of an amendment to a case in an appeal scenario under, I believe it's 1511, in that case, it is explicit that any party may at any time before judgment may apply. So there's an explicit opportunity provided to parties at any time before judgment to apply to amend their case. Now, in the review rules, there is no such equivalent. But my respectful submission is that that is because in the context of a review, what your lordships may do is within your broad mandate in the interest of justice to consider what is brought before you. So, my lords, for instance, respectfully, for instance, if in the context of an application for review, a matter that relates to compliance with the Constitution is being sought to be raised before you, as your lordships have made clear in many cases. When a matter related to the Constitution is being brought and enforcement, or there's an issue of breach of the Constitution which needs to be addressed, like was done in the famous Vulcan Energy case and so on, in that case, your lordships will, of necessity, respectfully, exercise your jurisdiction to entertain it, because your lordships are here to uphold the Constitution, no less, no more. So, respectfully, that is the difference between the opportunity provided under 1511, where appeals are concerned, and the review jurisdiction. Now, yes, it is conceivable, it would have been possible for the drafters of these rules to say that they are importing the same specific rule about amendments into the review jurisdiction. It would have been possible for them to do that. But, and I do not wish to enter into the minds of the drafters of these rules of court, because they are generally a very distinguished panel of, professionals, judges, and so on. And I do not wish to pretend to know their minds, but suffice it to say that in this CI 16 as it exists, they did not provide for that specific amendment rule when it came to review. They didn't do that. And my respectful submission that one cannot imply from that, therefore, that this court, in the exercise of its review jurisdiction, is bound from entertaining an application which involves an amendment. Because, in my respectful submission, this court has the jurisdiction and it has the opportunity in exercising its authority as far as reviews are concerned to consider what is in the supplement, what is, especially when a draft has been provided, and what is in the proposed amendment, and this court is able, in the exercise of its jurisdiction, to consider the matter.
Yes, my lords, we are opposed to this application on point of law. My lords, this honorable court has 6 distinct jurisdictions, different, one of which is the review jurisdiction. Lords, the rules governing review are very, very strict. And parties who seek a second bite of the cherry by way of review must strictly comply with it. My lords, insofar as the application before this court and all the other applications filed by the applicant seek to undermine CI 99, which basically, my lords, deals with my lords, I am dovetailing the point that the review jurisdiction is very, very strict. Yes, and I'm saying that the nature of the review do not permit the grant of this application. That is why my learned friend has not been able to cite one single authority on the point. All the references made, my lords, are in respect of appeals, and some regarding original jurisdiction. Original jurisdiction. I must. The first, yes.
We will give you leave to respond appropriately. Yes.
Well, that's my submission. That is my submission.
Yes. My lords, we are opposed to this application. First, our submission is that this review jurisdiction of this court is a very special jurisdiction. And you are, because of its special nature, the parties are given only a month within which to bring an application. They cannot apply for leave for extension of time to bring an application for review. Unlike an appeal, where parties are given 3 months, and even after that, they may bring application for extension of time. My lords, this is because that jurisdiction seeks to have the highest court of the land review its own decision. Now, so no one comes to the Supreme Court applying to amend its review or grounds of review as of right. Where there have been cases where the Supreme Court has exercised its discretion to grant such amendment, they must be dependent, if any at all, on the specific circumstances of the case. My lords, our submission here is that the additional ground that the applicant seeks is on the face of it no ground at all. Because what the applicant is saying is that because Article 129, is it 4? 4 refers to the power of the court to exercise all other powers of lower courts. Thereby, CI 47 has been raised to a constitutional status. My Lord, with the greatest respect, I think that that argument is misconceived. Because if that were so, then all laws, acts of parliament, other subsidiary legislation, including CI 99, because they have their roots from the Constitution. From the Constitution, therefore also have been raised to the same constitutional status. My Lord, on the face of it, this cannot be, it simply cannot be a valid ground. Let me also add, with respect, that the Constitution actually provides a rules of court committee to make rules to govern the procedures of the courts of our land, including the Supreme Court. Does that mean, therefore, that CI 99 is also raised to a constitutional status? It is for this reason that I think that the court should not exercise its discretion in granting what is a palpably misconceived application.
Asasi Radio, not.
You will give you 5 minutes to reply on point of law.
My Lords, if I may start by responding to the last submission made by counsel for the second respondent. And if I may make it absolutely clear that nothing in my submissions suggests that I'm elevating CI 47 or any other CI to the status of a constitutional provision. Absolutely nothing in my submission. Second, I would respectfully submit that the right of review is indeed a right that is provided for in the Constitution. And your lordships have had the opportunity to address its significance in the case of Bernard Mona.
What's the point?
My Lord, it does, because...
No.
Yes, and my Lord, yes. My Lord, what I was addressing was the fact that...
With the nature of the rules that have been carved by the Rules of Court Committee,
We're not allowed
of Rule 54, we cannot entertain an amendment. That is the case, or supplement.
Right. My Lord,
That's why, Mr. Chairman, that is why you began your argument, your submission by saying that you are invoking the inherent jurisdiction of the court.
that is correct.
Yes.
That is correct. So my Lord, very well. My Lord, I will not refer to that case. I was going to refer to part of the judgment, but for the moment, without reference to that judgment, I just wish to say in response to that matter that in our respectful submission, the additional ground that we seek to bring, which relates to Article 1294, in our respectful submission, will also enable the court to consider the extent of its powers, the extent of its discretion in order to hear the review that we brought before the court. So that article of the Constitution is an important basis for the exercise of the discretion that we're seeking to bring. That is what makes that relevant. Now, my Lord, as far as counsel for the first respondent submission are concerned, my only response is that counsel has entirely misunderstood the nature of the application before this court. He's misunderstood the nature of the application before this court.
My Lord, with the greatest respect. With the greatest respect.
Because in the nature of the application that we have brought before this court, we are saying explicitly that this court under its inherent jurisdiction in the hearing of the review application has a range of powers that it may exercise in the interest of justice. It is absolutely also not correct that we did not cite any case concerned with a review. The case of Elistamako and the Republic, which was the first case that I cited, was precisely in the nature of a review. So it is simply false for anybody to say that the authorities we cited did not include something on review. Furthermore, we demonstrated that on this particular aspect, the exercise of the review jurisdiction cannot be any different from the provisions regarding an appeal in this particular aspect. That is all.
Please, you will rise and consider.
All right.
Asasi Radio 99.5. 99.5. Asasi Radio 99.5. 99.5.
And those have been proceedings coming to you live from the Supreme Court of Ghana here in Accra. The court reconstituted this time round with a bench of 9 to hear the review application, and a number of submission was made by the counsel for the petitioner, and subsequently we did hear the submissions of the counsel for both the first and second respondents. We cross over to the Supreme Court once again, where our court correspondent Wilberforce Asare is on the line to talk us through what has actually been happening in court and what it is that is going to be happening next. Wilberforce, and welcome back.
Thank you, Benjamin.
Yes. So, Wilberforce, what exactly has been happening so far in terms of the detailing, some of the highlights in the... Yes, just take us through.
Okay, so you would notice that the Supreme Court bench has increased to 9, and that is that Justice Amadou Tanko has joined the initial bench, and then Justice Herita Mensah-Bonsu has only joined. And so the panel is now 9, and that's a review bench that is hearing the review application by the petitioner. Now, just to also emphasize that the petitioner has also filed an application where he says that he wants to add some additional ground to the application that they brought for review. Now, that additional ground that he says he has brought is what has held the court up till now. The lawyer Chachichikata essentially is trying to emphasize that even though in the rules, strictly speaking, when you ask the Supreme Court to reconsider its own judgment, by way of a review application, you cannot come and add new grounds for that purpose. He's saying that by practice, the court has allowed such things to be done. And so in this instant case, he thinks that the court should allow him, on behalf of the petitioner, to file an additional ground that the court should consider before it reviews its own decision. And so it's a little bit, I don't know if I've been able to explain it well, but what it is that the Supreme Court has taken a decision. You are not happy with the decision. You are coming to them to say that, I think that you should reconsider your decision. But in coming to do that, you said that you have additional information that you want to add to your initial application that they determined. Then the court is saying that, in fact, the lawyers on the other side, that is the lawyer for the Electoral Commission, the first respondent, and the lawyer for the second respondent, Akutu Ampao and Justin Amenubo, respectively, are saying that the rules that govern review applications are very strict, and that if you are coming to the Supreme Court to ask them to review their decision, you cannot come and say you have additional grounds to add to your application that the court took a decision on before the court reviews the decision. He says that, strictly speaking, when you come for the review, all that happens is for the court to increase in number and to give consideration to the application that they ruled on and to give a further ruling on it to end the matter. And so that's all that has kept us waiting. Now the Supreme Court 9-member panel hearing the review application has decided to go back into chambers and to discuss amongst themselves whether they are going to grant the petitioners the ability or the opportunity to add to their application, or they are not going to allow them by sticking strictly to the rules that govern applications for review. So for now, we have to wait for the Supreme Court to review and to tell us what their decision is, whether or not they are going to allow the petitioner to file those supposed additional grounds, or they are going to tell them that you cannot do that, and so we have to determine your review application the way it is as it stands. Benjamin.
All right. And, the counsel for the petitioner, in advancing his case, why consideration should be made for the additional grounds for which they are seeking the review. I mean, they did cite copious portions of some legal precedents, that's certain decided cases. It came across as a lot of them were with respect to appeal cases. And that was one of the arguments advanced by the counsel for the first respondent, indicating that no specific instance of a judicial precedent in respect of a review application had been cited, to which the counsel for the petitioner indicated that the very first case that he cited was in respect of a review application. What does that portion of legal precedent do? What do they do for his case in respect of the decision by the court, whether or not to allow for that addition as well as amendment?
So if you remember, during the presentation of the lawyer for the petitioner, one of the justices, Justice Gertrude Tokono, asked him whether or not the full import of his application is to show whether largely in the law what he is asking for is not explicitly stated. However, by practice, the court has used its discretion to allow things to happen. Mr. Chachichikata painted a picture that is not really what he is saying. But the sum total of everything he's saying is that there is no precedent in terms of the law to affirm the fact that the court at some time in a review application allowed what he's asking for to happen. But he's actually saying that by practice, the court can use its discretionary power to allow that to happen in the interest of justice. And that is really the full input of what Mr. Chachikikata is saying. So he is not able to present any legal basis, any legal ground, any clear statute that we have in our rules to support his argument. But he's essentially saying that in the interest of justice, and as has been the practice in some cases that have happened in respect to appeals, he thinks that in this particular case of a review application by the petitioner, he thinks that the Supreme Court can use its discretionary powers to allow him to file those additional grounds before the court hears the review application. I was sitting with somebody and the person said that this has become very academic because then it looks like we are doing an academic exercise instead of adjudicating an election petition. However, for now, the court has risen, I should say, and they say they are going to consider the case. Once they consider this application and they come back with their ruling, we will see how the case progresses. But the argument that Mr. Chikata seems to have been making the last 1 hour is about the fact that I'm not able to point to any specific law or any specific precedent. But I think that in the interest of justice, you should allow me to file this my additional ground before you consider my application for review. And so now it is literally at the beck and call of the Supreme Court justices. What they say is indeed what we will have to work with. If they come back and they say that, okay, we are allowing you to file those grounds, that will happen. If they come back and they say we are sticking strictly to our rules, there's no precedent, there's no law that tells us to grant it, and so we are not granting it, then we will move on again. I don't know if that will necessitate another review application. I hope not. But let's wait and see what the court will say. Benjamin.
Sure, we'll wait and see what the court will say. But before we let you go, in his submission opposing the present or the motion or representations made by the counsel for the petitioner, the counsel for the second petitioner was making reference to, I think, Article 1294 of the Constitution in making a certain opposition. Just give us a sense of, to the layman, what was the specific argument that counsel for the second respondent, that is Akoto Ampao, was making in opposition to the representation that had been made by counsel for the petitioner?
Okay, so I think that it would be good for us to read specifically what Article 1294 of the 1992 Constitution says. But I cannot readily remember the full thing, and I don't want to paraphrase. So I know, being in the studio, you're capable of getting that. If you probably are able to raise that provision, Article 1294, for us, we'll be able to situate the position of Mr. Akoto Ampao appropriately, specifically Article 1294 of the 1992 Constitution. Benjamin.
Yes, so I'll do that right about now so that we can look at it together. So Article 1294 of the 1992 Constitution says, for the purposes of hearing and determining a matter within its jurisdiction and the amendment, execution, or the enforcement of a judgment or order made on any matter, and for the purposes of any other authority, expressly or by necessary implication, given to the Supreme Court by this Constitution or any other law, the Supreme Court shall have all the powers, authority, and jurisdiction vested in any court established by this Constitution or any other law.
Okay, so that situates the discussion, and exactly the point that Akoto Ampao was making, that indeed the Supreme Court is the highest court of the land. And so every other court, no matter the decision that you have taken, you are subject to the ruling of the Supreme Court or the position of the Supreme Court. But he says that this particular application that is before the court is asking the Supreme Court to review its own decision. The application is not asking the Supreme Court to review the decision of, say, the Court of Appeal or the High Court or a district court or a circuit court. This time around, the Supreme Court itself, in its own wisdom, has taken a decision, and you have come that the court should review its own decision. And so if the court allows you to bring any further information beyond what you provided, for which the court took the decision that it took, then it will look like the Supreme Court is not exercising its authority the way it has to exercise it. You brought a case before the court. The court adjudicated it and, as it were, dismissed the application. You are not happy. You want to review it. But you are going back and saying that when you filed your case, you probably left some things out. So you want to add those things before the court takes this decision. It is new. It is novel. It hasn't happened because there are no authorities to support it. That is why the petitioner's lawyer himself was not able to raise any specific authorities that is in relation to a review application in which that kind of permission was given by the court, except in appeal cases where it is allowed technically in the law. And so, Benjamin, you and I, because we are not the court, and we are not justices, we will have to wait for the justices to decide on this matter.
Okay.
But on the face of it, it sounds complicated, if you ask me.
So, I mean, in essence, what the respondent, the counsel for the second respondent is saying is, in the Constitution, there is no specific provision in there to support the argument of the counsel for the petitioner. In the same way, looking at legal precedent, there isn't any such. Neither is there any in an act of parliament or any other subsidiary legislation. And so the court should not admit this particular application for amendment and for an addition to be made, in essence.
In essence, yes. In essence, that's essentially what the court is saying. And that's essentially the argument that the respondents are saying in this matter. We have to wait for what the court will say, because indeed, what the court says is literally the final thing. Once the court says it, that's it. That's what we have to work with. And so we have to wait for that. But it's an interesting development in this case, because what we should also establish is that the substantive petition is not being discussed now. These are auxiliary matters that are coming up as a result of the petition. The petition itself, the time is still running, and we have today, no work has been done on the petition itself. After the filing of witness statements and submissions on preliminary objections, no work has been done on it, because now there's an argument as to whether or not I should be allowed to file other information before you decide my application for review. That's where we are. Once that is done, then we will probably move to the substantive matter, which is the election petition, which is before the Supreme Court.
And just in connection with that, so listeners understand where we are, this is just an application to add additional grounds for the application for review. This will have to be determined before the application for the review will actually be heard. Is that what the case is?
Yes, sir. That's essentially what the case is, because even though it is the review panel that is hearing this application for additional grounds, which is actually the right thing to do, because if you are asking for review, there should be a review panel to hear everything associated with the review. And so that's where we are now. They have to decide whether they will allow that. And if they allow that, that also probably has implications. If they disallow it, that also takes the case in a particular direction. The applicant may have to move his review application straight away and get the court to determine. Again, you should know that because CI 99 has put up strict timelines governing this election petition, no matter all these side applications that are coming, the court still has a duty to ensure that it stays within the timeline. And so if this review application is put aside, then the court will now be able to set strict timelines to try this matter, because that's the stage we are now. All the necessary things have been found. What is left now is for trial to commence. So hopefully this application for review will be determined quickly as possible, so that the substantive case involving the petition that is before the court can be dealt with. That's where we are, Benjamin.
All right, thank you very much, Wilberforce Asare. Wilberforce is our court correspondent. He's also actually the head of the Judicial Press Corps, and he's also the head of our legal and political desk here at Asase Radio 99.5, bringing us summaries of what had happened just in court. The Supreme Court has risen to consider and take a decision on the various submissions that have been made by counsel for the petitioner as well as the first and second respondents in this particular case of the election 2020 petition. The matter they are considering now is whether or not to allow additional grounds as have been filed by the counsel for the petitioner in the consideration of their application for review of their earlier application to serve or to file interrogatories on the first respondent. And here, the first respondent is the Electoral Commission, represented by its chairperson, Madam Jean Mensah. So this particular situation, or this particular one, has to be determined. That is whether or not the court will allow for those additional grounds. Once a decision has been taken on that, then the court will now consider the review application of its earlier decision as it took in respect of the petitioner's application to file interrogatories on the first respondent. And those interrogatories were 12 specific questions which were filed in the petitioner's application to be served on the petitioner, to be served on the first respondent to answer certain questions, among which is whether or not, for instance, the NCA aided the Electoral Commission in any way when it came to the transmission of results, among other things, including also whether or not this is the first time that a regional collation center is being included in the hierarchy of things. We are aware that in this country, for our elections, election results are declared at polling stations, and then they are collated at the constituency collation center, after which it goes to the National Collation Center. But for the 2020 election, we know that as contained in CI 127, which governed the elections that were carried out, there was the introduction of regional collation center. So that is one of the questions included in the interrogatories that the counsel for the petitioner is seeking to be served on the first petitioner for them to provide answers to. And so this is where we are. After that, after the court has made a determination on the review application, then the substantive petition will continue. But as it stands right now, we are not there yet. And there seems to be a lot more that is going to be happening in respect of this particular case. Stay here with us on Asase Radio 99.5. We'll be bringing you all the details with the most in-depth analysis. Of course, you can clearly tell that the team here is up on the beat with a clear understanding of what is happening. And we have the right resources in terms of lawyers to fall on to give you the best simplified explanations for you to understand the court processes as they do unfold. My name is Benjamin Ofe Ado, and I've been the host of The Breakfast Show together with Nanaya Mensah. We'll come back to you and bring you whatever ensues when the court reconstitutes. In the meantime, though, we'll take some music as we await the court.